Hmm. It's a question which is loaded and also relates to the past. I happen to be a student of history and also a witness to many attacks. In addition to being the Attorney General, I've also served as the Advocate General twice. And in that, in a lesser context in terms of the province. So my duties were to advise the government in the province and to represent the government in the province. I've had several spates with the executive and also the judiciary, and I've also seen how things turn. So not that I say I'm an expert, but as a spectator and an actor in all this, I think I have seen more than what you or others would have felt and what Mr. Athar has said. Now, he's not the only person who said this. I have seen a trend, and starting from Qazi Faiz Isa, who then became the Chief Justice, writing letters, and before the letters were even sent, they were leaked to the press. And then I've seen all those letters coming in from other honorable members of the bench. I've seen letters by the High Court judges. And again, those letters were not addressed to the Attorney General or the Advocate General, not even copied to him, except for Qazi Faiz Isa. He would copy those letters to me or even address me in those letters. Now, what are these? Let's not go to the personalities. What are these letters about? Are these letters about how the Constitution or an institution has failed, or how better progress can be made in the decisions, or how the High Court should be working or the Supreme Court should be working? Instead, I've found a tinge of personal likes and dislikes and personal opinions in those. Now, yes, everybody's entitled to his opinion, her opinion, their opinion. But then, the higher the office, the bigger the responsibility. Now, if you were to criticize your institution, for instance, a doctor, and he says, the hospital that I work for is not working properly, the MS is interfering, the chief executive of the hospital just takes money home and does not spend it on the hospital, will he not lose patients? Will there be any confidence in that hospital? No. Educational institutions, this, that, and the other, all institutions. When a voice comes from within, criticizing the institution and criticizing it not for constructive criticism, but for personal reasons, personal vendetta, personal grievances, personal experiences, I think that's where the line is crossed. And it goes against the Constitution. When a judge makes an oath, when he makes an oath to set aside all his personal knowledge, personal opinions, personal likes and dislikes aside. He has to set them aside and then decide in accordance with law. And there was a Chief Justice, and I reminded him, I'll not name him, that he had once written an article who said, he said, a judge who opens his mouth shuts his mind. And he said, this was not what his thought process was. This was what Denning had said. And I looked up Denning's judgments, and yes, indeed. So it's not the first time that something of this nature has come out. But I tell you, there is so much of weight in what he said. A judge who opens his mouth shuts his mind. Very profound. And I think this is something which we should be adhering to. And this is exactly what the Supreme Court should, or the High Court should be doing. Why? because it is not just ingrained in morality, but also the very oath that one makes. And if you do some dereliction, or if you violate your oath, then you're exposing yourself to three things. You become controversial. Number two, you're stepping away from the institution, not being a part of the institution. And thirdly, you expose yourself to Supreme Judicial Council's mischief. Now, mischief is not what mischief one talks about in the dictionary sense. Mischief is within the scope of the jurisdiction of the Supreme Judicial Council, where you can be tried for violating not only the oaths, but also the code of conduct. Now, what is the way forward if you have a grievances? Is this not your constitutional right to speak out? It is. Is it not your obligation to point out defects? It is. But there's a way of doing it. You do it in private. You do not leak these letters. You do it by meeting the individual that you have a grievance with. You call a meeting of like-minded. You have the right to sit in the administration committee of which you are a member and say all those things and keep them private and confidential. Why? Because that would erode public confidence. And what are courts there for? They're not to decide matters between the government and the court. They're not there to address the grievances of each other. It is not a club. It is for the people. It is for the public. And if public opinion or the public confidence is eroded, then I'm sorry to say you're not doing any service to the nation, you're not doing any service to the institution, and you are not doing any service to yourself. Because you are then under the weight of your own opinion. Now, it was a short question, a long-winded answer. I can go on, but then we can sit and talk about this, yes. Now, did he say this in a judgment? No. Did he say this while hearing a case? No. Did he say this in writing? No. This is exactly what is prohibited. It is prohibited. You do not, and this is his personal opinion. Personal opinions are not to be expressed. I am reminded of an invitation which was sent to the Chief Justice for the purposes of administering oaths to a very high public functionary. And he said, I will come in after the gentleman has arrived in that hall. Why? Because I do not want to be seen mingling with people. So mingling is also not something which is to be done. Why? Because then somebody would put you a question and then you'd be answering that question and then you'd be quoted or misquoted or whatever. When I was growing up, and I'm still growing up in the profession, I saw judges avoiding marriages, ceremonies and all that. And they would not go to inaugurations of exhibitions and things like that. Even as Attorney General, I would not do that. But then we're not talking about the Attorney General's office. I'm talking about the judges. Right? When we talk of a hybrid system, is it hybrid? Is it a mix or match? Or is it a mix or mismatch? That history will tell us. And we have seen all these systems changing colors, changing spots, changing the shapes and all that. And Mr. Manullah, if I recall correctly, was a minister when there was dictatorship in the country. Was he not? So I have great respect for him. He's a brilliant judge. But your brilliance should be reflected in judgments and not your personal opinions. Secondly, tell me in the US or in England or other places, whenever there is a need, aren't the armed forces called upon to address issues? National disasters, Hurricane Katrina, you saw Marines, you saw Navy people, you saw the Army, Japan, England. Now, what are we doing? Don't you want an inclusive society? Or do you want to have islands? And I have several times said this, and I will repeat myself. We should not create islands when there aren't any. We should, if there are any, let's build bridges. Why? Times have changed. Starting from monarchy, we got into democracy, and from democracy, we went on, and don't we see what is happening all around us? Did Hitler not get elected? Was Mussolini not elected? I'm not saying that democracy is not good. Certainly is. But then should we blindly follow what we have read and romanticize? Or should we think on practical terms? I leave it to you and also to people who are listening to our conversation. Judicial conferences are a good thing. I'm kind of surprised if there's a conference and not an opening of a judicial year, because when the courts reopen after the summer break, then the first order of the day is a address of the Attorney-General, address of the Supreme Court Bar President, and address of the Chief Justice. We would talk about the past. We would talk about what has happened recently, that is the present, and look at the future strategies and what is expected of us collectively. It is for the Chief Justice and his companion judges to address these issues, and I'm sure communication is the key to solutions. And if there is a communication gap, there is a problem. But if there is no communication gap, if you're talking about things, certainly good will come out. Certainly. I'm very confident in that. I'm a very, very positive thinking person. I'm not pessimistic at all. I have great faith in the institution. And sadly, when these things surface, they indicate a division, which is to be avoided. Well, there is this kind of criticism. You saw this even earlier when one read the letters written by the 5 judges of the Islamabad High Court and similar issues. I think only history will answer this question as to how this is being handled and all that. In my personal opinion, open plans, open strategies, openness in communication is the key. And if this is adopted, problems will not arise. But is this a public debate? The answer is no. This can't be a public debate. And if it is a public debate, then it is to be done by the other side. People from across the bar, not the bench, but the bar. All these issues highlighted, I will be re-emphasizing that these issues need to be addressed not publicly, but privately. And I've seen them grow together. They were in college together, maybe a year's difference. They worked together. They've been great friends. I'm sure they will be able to iron out these creases, so to say. I think these demands ought to be coming from the litigants, if these demands are to be made, not by the judges and not publicly, because again it erodes the public confidence. It confuses people. Why is a particular judge keen to hear a particular case is something which is not known in judicial history. Also, Article 239 very clearly says that the constitutional challenges cannot be made to the amendments in the Constitution. And unless there is a procedural issue there, and there isn't a procedural issue, the question is whether this affects the independence of the judiciary or not. Many years ago, question arose whether judges who were to be affected by a particular notification ought to be hearing the case or not. And the answer of the full court was, if there are no other judges available, then even those judges who are affected by the notification can hear the matter, and they will not be judges in the same cause. Now, it's very, very interesting how times have changed from that judgment to what we have today. At that time, the Constitution did not have even a semblance of a constitutional court. And Supreme Court was, as a court, a constitutional court. All High Court is a constitutional court. It is created by the Constitution. But now we have, by dint of law and the amendment in the Constitution, a very clear mandate. The mandate is that all challenges of a constitutional nature are to be heard by the constitutional bench. So they will have to be heard by the constitutional bench, and that is a complete answer to that. There is a short answer and there is a long answer, which will be spread over many sessions. I'll prefer the short answer. I have been an advocate for All Pakistan Judicial Service, where lawyers, academicians who have studied law, professors, they all should compete for the positions in the subordinate judiciary, the higher judiciary, and the Supreme Court of Pakistan. No harm done. I tell you, no harm will be done. Lawyers community will not like what I'm saying. I think direct recruitment from the bar. No, don't do that, because then it will be pick and choose. If it was before the amendment, then it was the Chief Justice. He had the initiation and the last word. He was the one. And now it is the parliamentary committee, along with the Judicial Commission, they all form together, and they are one caucus. They are one. If you don't like it, maybe the word that I'm using, the expression that I'm using, may not be very palatable, but it is like an electoral college. And you have electoral colleges for judges elsewhere in the world as well. But let's go back to what I was saying. All Pakistan Judicial Service, and there you would have specialists going in for criminal work, going in for civil work, going in for taxation, going in for customs, going in for family issues, sit, compete, get training, and then become a judge. Market salaries. Secondly, and equally important, and that is in-service training. And all these issues which need to be addressed, for instance, their seniority, their terms of service, and all those issues. And thirdly, again something. Now, you can have from this All Pakistan Judicial Service additional secretaries in each of the departments from the trained people who would then be advising the government in various departments on legal sides. So that's one way of tackling it. The other way of tackling it is, and that would be caseload. And how do you do that? We have the civil judges, the district judges, we have then the High Court, and then from the High Court, the intra-court appeals, and then the Supreme Court. Nowhere else in the world except for India, you have these issues. So one appeal, an appeal from where? Not the civil judge. Abolish the office of civil judge. It should be the office of additional district judge. And in the criminal side, on the criminal side, it should be the additional sessions judge. So you should have a district judge and you should have a sessions judge. Now, one appeal from that to the High Court. Now, that is taking out one tier, putting efficiency in all this. No revision, no issues relating to writ petitions and all that. It should be that way. Having said this, I've seen something which I think needs correction. And it's not so much of correction, but also it is very much about a vacuum which needs to be filled. Now, we have customs judges, we have income tax judges, we have judges doing banking work. These are all federal laws. Why can't we have federal courts, which we do have, but the appeal goes to the High Court? Why can't we have federal high courts hearing matters relating to the issues relating to federal laws and appeals from there to the federal Supreme Court? That will create a system which would be parallel, which would be merit-based, and which would be efficient. And we can keep talking about this, but the key is market salaries, appointment on merit, competition, and decisions in accordance with law, not your personal opinion.